So it's just a regular pre-trial instead of
Yeah.
Okay. Okay, let's go ahead and on Antonio Waldo, let's go over the motion to eliminate, and I am looking at Mr. Kazmarik's motion. And so the first is excluding witnesses from the courtroom, prohibiting witnesses and parties from disclosing nature of claims. Is there any argument on that?
Excluding witnesses, I think under the court rule, Judge, they're not allowed in here.
Right,
So we're not gonna keep any witnesses in the courtroom
okay,
before or after, Judge. But
okay,
I think it's on YouTube. So when we had the last trial, there was also an order that witnesses not watch on YouTube the testimony. So I'd ask that that be granted for both sides. I think the defense has a witness and that they be told to not watch the YouTube and what's going on.
We do, and we put that in our motion as written.
Yeah,
Second line,
I don't-
you know, just that the court instruct any witnesses not to view the proceedings remotely.
and from YouTube as well?
Yes, Your Honor.
Okay. Okay, that's granted. Motion to preclude the state from introducing any statements by and against that have not been disclosed. Argument?
All statements have been disclosed, Judge. We
Okay.
don't object.
Your Honor, actually, I think we probably do need to address that. I received an email, 4:30 on Friday disclosing the contents of, if you look at the state's pretrial memorandum, second paragraph of the background section beginning in June of 2020.
Okay, just one, hold on, let me get that. Okay, background, second paragraph.
In June 2020.
Yes, I got
the defendant
it.
was drinking at the park, and all of the statements contained in that, that the defendant allegedly became very angry, called Mr. Bromo a mallcrop, Mexican short, threatened him, etc. Those statements were disclosed to us at 4:30 on Friday. They weren't provided in any discovery or notice from the state prior to that, and we would ask on the basis of that those statements, allegedly made by Mr. Waldo, that Mr. Romo is planning on testifying to, be excluded.
So they were not in discovery at all until Friday?
No, Your Honor.
Okay. Okay, Mr. Crowell?
Your Honor, we did provide to the defense a CAD log entry, which was last Tuesday. And in the CAD log entry, I got it on Tuesday and I got it to Mr. Kazmarek on Tuesday and advised him of this. And in the CAD log, it indicates reporting party advised the male threatened the reporting party when he catches him outside of here. The vehicle is back at the park heading back to the beach. There was evidence of a prior threat against the security guard in that CAD log. And I would also note, Judge, that the defense had an investigator that went and talked to Mr. Waldo several, I believe, months ago. Not Mr. Waldo, but Mr. Romo, several months ago, before the state even had any contact in this case with the security guard, and had the ability to interview him about any past statements. When I met with Mr. Romo, the security guard, on Friday, he told me these statements, which corroborated the CAD log that he was threatened, and disclosed that as soon as I got more details of that.
Okay, Mr. Kazmarek?
Well, so a couple of issues with that, Your Honor. One, we're talking about two different instances. That CAD log documents an interaction that happened on July 7th. One, it wasn't provided until last Tuesday, so 6 days before trial, 5 days after readiness, and this is a police report that's been, a document that's been in the state's possession since this case came around last July. Two, I'd argue those statements were hearsay, right? The CAD log is just a recording of what Mr. Romo told the police officer. The state has indicated in his, in its motion that today, Mr. Romo plans on testifying that he didn't even speak with the defendant on July 9th, which is the date that that CAD log is from. our investigator did meet with Mr. Romo. He didn't disclose anything about threats or abusive language or alleged racial slurs or anything like that. We filed the standard discovery request at the outset of this case, including a request that the government disclose any statements of the accused that they were planning on using. Those were never disclosed until, like I said, the Friday before trial. Any of this stuff that happened prior to July 9th, we got notice on 4:30 in the afternoon on Friday via email. And we'll talk, I guess, about the things that happened on the 7th. I've got a separate, I'm going to verbally supplement our motions and eliminate with a request to have Deputy Ross excluded. But with regard to the statements that were allegedly made on June 2020, again, our position is that this has been the government's witness the entire time. They've had access to him, and they're, telling us literally on the eve of trial, the last business day before trial, at the end of the day, that oh, by the way, there was a past interaction prior to anything that had previously documented in the disclosed law enforcement documents. It included a bunch of very offensive statements from Mr. Waldo, and we'd argue that those should be excluded, primarily due to the lack of notice, but also, we'd argue that the nature, tenor of his interaction with Mr. Romo, tended to be prejudicial and isn't directly relevant to the question of whether he was authorized to be at the park on July 27th, which is the legal issue that we're here to decide today.
If I may respond.
Wait, I just have a couple quick questions. So did you not know until Friday there were any threats made?
That's correct.
Okay.
He didn't say anything about that when he spoke to our investigator.
And the investigator did have the opportunity to speak to Mr. Romo, is that correct?
She interviewed him in November.
Okay, and do you know whether the investigator talked to him about what type of interaction they had?
She was focused in on I'll give you a moment, Your Honor, his statement here, where they're, so he talked about what happened on July 7th with our investigator. He said that he asked Mr. Waldo to leave several times. At one point, Mr. Waldo left, and another point he came back, that he'd been in disputes with other guests at the park, but he didn't say anything to our investigator about any sort of verbal abuse or statements or threats that were made by Mr. Waldo to himself when our investigator interviewed him back in November.
Okay, Mr. Crowell, what do you want to say?
Oh, Judge, the CAD log does, like I said before, was not in our possession. It was, I gained it on Tuesday of last week, and it does indicate that there was threatening behavior by the defendant that towards the security guard.
Now, when you say threatening behavior, does it say speech or does it just say behavior?
It says the male threatened the reporting party. When he
Okay.
catches him outside of here, that he's threatened him. When he catches him outside of here, he's gonna hurt him, essentially.
Okay,
And that was the first day I had this. This was not part of the original police report that the state was given.
and that's the first day that you were given that?
I obtained this last Tuesday. It's not part of the police report that was sent over by the police. It's not something that I had custody of at any time until Tuesday, and I immediately turned it over. We think the fact that the defendant had threatened the security guard, whatever date it was, on a prior date is relevant because it goes to show why he would know he's not allowed back in the park. The state has to prove beyond a reasonable doubt that he knew that he was not allowed back in the park. It's even that much more significant that he had a conflict with the security guard. Whether that was on July 9th or back in June,
Okay.
that may be an issue that the defense can raise, obviously, but we think that we turned it over as soon as we had it. And we didn't have this in our police reports before Tuesday. I turned it over immediately. And if it was as well as the depth of Mr. Romo's statements, I obtained on Friday. And I would say the defense had interviewed this same person 6 months ago. And so the fact that their investigator didn't fully ask him about the prior interactions, that's not the state's fault.
So did you have a copy of that? Did you get a copy of that catalog where it mentioned threats on Tuesday?
I did get it on Tuesday, Your Honor. I guess I would dispute, I mean, it's all well and good for the prosecutor to not have, you know, a piece of evidence in his or her hands, but, you know, this is a police record. You know, they are not a legal office, they're a representative of the state of Washington. And the state of Washington has had this police report, or this catalog, the entire time. In the police report we were provided during initial discovery, the officer who responded that night says, I checked with Cowlitz County records and saw that there was a signed and served trespass order on July 9th. I inquired, what is this order? Can I get a copy of it prior to trial? And the response I got was, you know, again on Tuesday, after readiness had been called, oh, well, there's not a signed and served order. All it is a catalog documenting this verbal interaction. I'll go down to records and get it. And then it was turned over on Tuesday. So
Okay.
I guess I'd say that I'm not saying that the DA's office was trying to hide the ball, but they're responsible for records that are in possession of the government. They should have known from reading the police report that this substantiating document that references what that signed and served order was existed, and it was incumbent upon them to seek it out and to provide it, especially if they're planning on introducing it during the trial. We requested all reports in our form discovery request that we sent out when we were given this case in July or August of 2020.
Had you requested the catalog?
I requested a copy of the order. I didn't know at that point. It wasn't until, again, I think last Tuesday that Mr. Crow responded and said, you know, well, there isn't actually an order. All it is this catalog. Also, we're adding Deputy Ross to our witness list.
Okay. Okay, this is what I'm going to do. It sounds like the state also did not know that there was not a formal order. It was a catalog. I'm going to allow the threat. I'm not going to allow any racial slurs at all. So let's go ahead and let's limit it. So it said, let me look. We can get threats in. We cannot get in the part that he called him a Mexican. He called him short. I don't think that's really relevant.
Your Honor, is the court finding that 404B evidence that the probative value outweighs any prejudicial effect?
Yes. Yes, I do believe that that is more probative. And what else do we need to discuss? Is there anything else we need to discuss?
With regard to this issue, Your Honor?
Yes. So there's not going to be a formal order introduced, is that right?
Right, it's just an oral order.
Just the oral and on the CAD, okay. And again, it also says in here, the state is not seeking to admit any post-Miranda statements, is that right?
Yes, Your Honor.
Okay. Okay, is there anything else?
I think we're on number 3, right, Mr. President?
That's correct.
So the motion excluding testimony from Romo law enforcement concerning the consumption of alcohol.
Okay, argument on that?
Again, Your Honor, it's not, I think, relevant to the allegation, right? The state is here to determine whether or not he was authorized to be on the premise on July 27th. And so I think, again, Mike Romo coming in and testifying, this is sort of a piece with the previous stuff that we discussed.
Are we talking about him drinking alcohol? Is that what you're talking about?
Yes, Your Honor.
Okay, go ahead.
You know, it's not relevant to the legal question of whether or not he was authorized to be on the premise, and we believe that it, you know, is just going to tend to potentially cause the jury to, it has no effect other than to potentially cause the jury to view him in a more negative light than they otherwise would. It's not probative to the legal issue, and therefore we believe it should be excluded.
Okay, Mr. Crown.
Yeah, on the July 27th, the security guard will testify that the defendant was in the passenger seat of a white truck and drinking alcohol. When Deputy Potter stops this truck, she notices the defendant in the passenger seat and is exhibiting the effects of habit consuming alcohol. It goes to identity on that date. This was the same person that was at the park that was trespassed. If the defense wants to stipulate that his guy was at the park on July 27th and not challenge the identity issues, I think that's relevant. I think that when the defendant was trespassed 2 times, one by Deputy Ross, but earlier by the security guard told him he couldn't come back for a year. The reason for being trespassed was that he broke park rules. Park rules are you don't consume alcohol at the park. And it completes the understanding the res gestae of the crime, that the jury know that this person was trespassed for breaking park rules. And that park rule was that he was drinking alcohol at the park, and that's the basis and the justification for the security guard to exclude the defendant from coming back to the park for a year. So I think it is relevant for both of those purposes. It also becomes relevant if the defendant testifies. So that would be a separate issue, but if the defendant testified, the fact that he was consuming alcohol would affect his memory.
Okay, I'm confused. So she could have identified him without saying that he was intoxicated in the car, right? Or he was drinking alcohol? Could she not identify him otherwise? How does the drinking alcohol tie into her identifying him?
It ties in because it's the exact same things the security guard said. He was in the passenger seat drinking alcohol. And then when she stops the truck, he's in the passenger seat having shown signs of consuming alcohol. It connects Mr. Waldo back with being at the park that day.
But is that the only connection, is only the fact that he was drinking alcohol? Couldn't she identify him anyway?
It connects both the security guard and the officers, because the officers stopped him away from the park, not in the park. And so when the security guard, Romo, testifies, I saw him in this white truck in the park, he had already been trespassed, and he was in the passenger seat, and he was drinking alcohol. I've got to prove beyond a reasonable doubt that he was in the park, and that and they proved that he was in the park that day in violation of the trespass orders. He's in a white truck, he's in the passenger seat, and the officer sees that he's exhibiting the signs and effects of alcohol. It corroborates exactly what the security guard would testify to. On top of that, there was nothing illegal that he was doing there as far as alcohol is concerned. He's over 21, he wasn't the driver. A huge part of our population drinks alcohol. So the prejudicial effect is very minor.
Well, except you said that he was also, she could tell he was affected by it. Isn't that what you said? So he isn't just drinking it, you want to say he was affected by it.
I just want her to corroborate that she noticed the signs of alcohol on him, not that he was intoxicated.
Okay. Mr. Kazmarek?
The security guard provided law enforcement with a description of the vehicle, including the license plate. The officer initiated her contact with Mr. Waldo and the driver of the vehicle based on the fact that she saw a white truck with the license plate that had been reported. Mr. Waldo identified himself by name to the
Was it the
officer.
same license plate that had been present before? Same truck, same license plate?
On the 27th. So not this truck and the individual who was driving the truck were not there on July 9th. But yeah, so the officer, the security guard reports there's a white truck with this license plate. This individual's been trespassed. Also, he also reported a suspected DUI, and then the officer pulled the truck over. And like I said, based on same make, same model, same license plate, same color, and Mr. Waldo themselves to law enforcement officers. So I guess we don't think that there's any additional probative value to anything about whether he was intoxicated that evening.
Okay, I'm not gonna allow the intoxication or the alcohol. Now, if Mr. Waldo takes a stand and that should come up and he opens the door, that's gonna be something different. But as far as, this is not an alcohol crime, this is a trespass. And so based on the fact that it's strictly a trespass, I'm not gonna allow the fact that he appears to be inebriated or under the effect when she stopped him, especially if he's identifying himself. So does that take care of number 3?
Yes, Your Honor.
And who was going to testify, Mr. Cowlitz, as to the fact he was drinking and he was under the effect? Was that Potter?
Yes, Judge.
Okay, so then you'll let Potter know to leave that
Yeah,
out?
and I'm gonna need a few minutes with each witness to be able to let them know the things they can't talk about.
Perfect. Okay, what else?
We have number 4, although it might make sense to handle a verbal motion that I'm going to supplement our motions and eliminate with first, because depending on the court's ruling on that, it may move part of what we were trying to do with number 4.
Okay,
And so we're going to move to exclude any testimony by Deputy Ross. And again, this is due to a late notice. The government provided its witness list months and months ago. The only 2 names on it were Mike Romo and Deputy Potter. I didn't find out about Deputy Ross, the existence of Deputy Ross, anything about Deputy Ross until, again, after I approached the government affirmatively as we were leading up to trial and said, hey, can I get a copy of this order? And then was informed on Tuesday, so 5 days after readiness, 7 days after the 14 days out that the court rules have established for providing notice of witnesses to the opposing party before trial, and 6 days before the trial itself, that, oh, there is no signed order, there was no certified order or whatever. This order from law enforcement only comes from this officer, Deputy Ross. Oh, by the way, we're adding him to our witness list.
okay, I have a question for you. So did you not ask for a signed order months ago?
I believe it was in early May, Your Honor. But again, we did in that we filed a discovery request at the outset of the case requesting all law enforcement reports that are relevant to this allegation. I'd argue that that catalog is a law enforcement report. Again, it is the government has an affirmative duty to turn over the evidence. I would argue even without a discovery request, but it would be included in the materials that we asked for when we sent the discovery request over to the government. It's a courtesy / we need to get what we need to get for us to follow that initial request up with a, hey, I think this should exist, can you get it for me? But again, this was in the possession of the government the entire time and was not turned over until Tuesday. And in addition to turning it over, the government provided notice at that point that a law enforcement officer whose name had not been disclosed, either in a witness list or any other form, who gave this verbal trespass order to Mr. Waldo, is now going to be added to the witness list.
But it sounds like the state just found out about the cat on Tuesday, right?
That's correct, Judge. And the catalog is not a police officer reported, it's not a police report, it's a 911 Spillman report that is different than a police report done by a police officer. So it's a 911 officer typing notes that a police officer is telling the 911 officer. So it's not something that we knew about, was in our control as a prosecutor's office. A prosecutor is not in control of the entire state and all documents. We're just in control of what we have. And so I, trying to follow up on the defense request, discovered this. As soon as I discovered it on Tuesday, I immediately contacted defense and about 4 different ways tried to get it to Mr. Kazmarek. His computer was down. We got the catalog through old school and got it to him as soon as we could. Immediately we said, okay, this is the information that we have, and immediately turned it over and said Deputy Ross is the one that issued the trespass order and disclosed that. If the defense was like, whoa, wait a second. And on top of that, Judge, I will note that even though the defense didn't request this, I set up until Friday, I was like, do you want me to try to get an interview with you and Miss Potter and with Deputy Ross? And I coordinated that this weekend, and the defense talked to Mr. Ross, Deputy Ross, and Deputy Potter, in interviews that they hadn't requested before. And so we've given access to those witnesses. And if the defense felt like it was unfair last week, they could have said, hey, I want to continue this trial because this is, last Tuesday, there's plenty of court days to say, hey, I need more time to answer this new information. It was information we did not have, we did not know, and as soon as I had and knew it, I turned it over to the defense, and I coordinated witness interviews so Mr. Kazmarek would be prepared to represent his client. So had we turned it over, say, I knew about it 3 months ago, he's no less prepared to represent Mr. Waldo today than he would be 3 months ago. We didn't have it. So when we discovered it, we disclosed it.
Did you have an opportunity to talk to Deputy Ross and Deputy Potter?
I did, Your Honor, but the fact that I was given an opportunity again after readiness, well after the date on which the state was required per the court rules to disclose witnesses and evidence, we're in a situation now where the state has put Mr. Waldo in a position where he's got to pick which of his rights does he want to stand on. Does he want to have a speedy trial, a timely trial on the date on which he was assigned it, or does he want to further delay this proceeding, which has been hanging out for 10 months already at this point, so that I can have more time to prepare? I guess I'd also argue the state has an affirmative duty to seek out relevant evidence. This is the Cowlitz County Sheriff's Office. Like, these records were in the same building as the prosecutor's office for 10 months and weren't produced until 6 days before trial in response to an affirmative defense request for, hey, this piece of evidence seems like it's really relevant. I've noticed that you haven't turned it over. Can you please do that? Based on that, we believe that the testimony and the evidence should be excluded. The government should have to stand on the evidence that they gave us notice of in a timely manner, which is the testimony of Mr. Romo and Officer Potter.
Okay.
Yeah, could I respond to the speedy trial issue and just make a record on that?
Yes.
Per the court rule, the defendant's speedy trial started at his readiness hearing. And so under the local court rule, we have 6 months to try him from the date of the readiness hearing, which I believe our readiness hearing was 10 days ago. So we have 5 months and 20 more days under his speedy trial rights to honor that. So he's not been, under the court rules, lost any speedy trial rights and could have asked for continuance if he needed it and preserved the rights under speedy trial. We are not at the end of the clock. We're not even close to the end of the clock. He's out of custody with 170 days left of speedy trial.
Okay, I believe that Mr. Waldo could have exercised that right. I also believe that I probably would have granted that right had you wanted it. However, you did choose to go forward. You did choose to interview the 2 officers. I do not believe that the state was in possession of that information prior to Tuesday. I think they did what they could in order to make it available to you. Based on that, I am going to allow the CAD. I'm also going to allow Deputy Ross. Anything else?
I think the defense has number.
Move on to number 4, Your Honor.
Okay.
Don't you already have a copy of the discovery report?
I don't know.
Probably not. I don't believe I've turned it over.
I don't think I do.
File here, so.
I think it's got the file. Would have been original file.
Do you want me to look at it?
Yes, please, Your Honor.
Okay. Thank you. Now, how did the state happen to get the cat on Tuesday? Was it a supplemental report, or did you ask specifically?
I had to go down to records and request the catalog, and so it got printed then, and then I turned it over to the defense. And as far as the discovery request, Your Honor, that's a request, it wasn't an order of the court.
I do notice that it was October 2020, and it says number 12, all 911 calls catalogs. Do you know why it wasn't presented till last Tuesday?
I didn't have possession of it, Judge.
Okay.
I guess, again, may I speak, Your Honor?
Yes.
The state is larger than the prosecutor's office. This is a question of whether the government had possession of this evidence, which it emphatically did. It's a law enforcement record that the prosecutor didn't seek out relevant evidence that was in the state's possession. Is not, should not be a defense to a late notice argument. This is pretty basic, essential. It was referenced in the law enforcement report that was provided in discovery. So the idea that, well, we can just turn around and say we didn't have it because nobody bothered to walk downstairs and ask for it, and therefore there's not a notice or a discovery issue, strikes me as fundamentally just not the correct standard.
Well, I just want to understand what triggered him to go down and ask for the 911 tape. Did you make a specific request for an order, and then he went down and then found out?
That's correct, Your Honor.
Okay, and is asking that specific request, could that not have been made sooner than Tuesday? When did you make that specific request?
I mean, I made a follow-up request. I'd argue that the specific request was made for all catalogs and 911 reports.
Back in October.
Back in October.
Okay, but when did you make the follow-up request?
It was sometime in early May, Your Honor. I can't pull my email.
Okay, it's okay.
I don't have it specifically.
I would also point out, Judge, that at the pretrial hearing, this is what the defense does at the pretrial hearing, is they say, we need this, Judge, we want an interview with the defense, we need this report or that report, and that wasn't done in this case. And so when Mr. Kazmarek requested it, and there is an email from him last Tuesday saying, can you get this information, I went out and sought it and found it and turned it over.
I mean, it seems to me that asking for a trespass order, or it's kind of like asking for a no contact order. You know, that's kind of something you do from the very beginning when you're looking for discovery, right? You want to see a specific order. So I'm just wondering why it took until May to ask for a follow-up trespass order when it seems like that might have been something you might have asked around the pretrial or discovery time, if in fact there was not a formal trespass order.
So I guess I can't speak to the pretrial because that was on November of last year and I wasn't part of the case. But again, I'd argue that we did request it specifically. This piece of evidence is, as the court pointed out, unambiguously covered in one of the items that we requested when we filed our original discovery request. The state, it shouldn't be the defense's job to note the deficiencies in discovery and go back and follow up and request multiple times. I mean, I think I sent an email, one I can find was on the 14th, saying, hey gentlemen, pinging you again on that trespass order. It was then provided on the 18th. I think that it's this notion, well, we didn't turn over what we were supposed to, but you didn't ask for it a second time or a third time is not how this is supposed to work.
But they didn't have it either, right?
Well, again, I guess it depends on who they is. This is the government is, it's not the Cowlitz County DA's office. Mr. Crowell is trying this case today, but
Right.
he is a representative of the state,
Right.
the law enforcement body of the state. I think that if the state has it, then, his lack of personal knowledge is not something that, should be used to defend against, failure to turn over clearly relevant evidence in a timely manner.
So is that not something also that the investigator should have wanted to have seen? As far as if there was a formal trespass order when they were investigating?
I mean, again, our investigator was focused in on the, specifically interviewing Mr. Romo, right? We don't dispute that he told, Mr. Waldo that, he needed to leave. But that's, I think, a separate issue of whether there was a, and I think there's grounds to argue either way that he was authorized, that there doesn't necessarily need to be a law enforcement order in this case if he's the designated representative who's empowered to trespass people from this park. I guess Deputy Ross's name doesn't even come up in the police report. I didn't find it out until I asked again to receive evidence that we should have gotten as part of the initial discovery request.
Right, but you got the opportunity to interview him, and you chose not to continue, correct?
Sorry, the opportunity to interview Deputy Ross?
Yes,
Yes.
you were provided that. Okay, I'm going to allow the CAT. I'm also going to allow Deputy Ross. Anything else?
So that takes us back to 4.
Okay.
Which is basically, Officer Potter, in her police report, she was the one who responded on the 27th, wrote that the records department confirmed that there was a valid and served trespass order. Like I said, she heard this verbally through somebody in the records department. So I guess we just would ask to have any testimony from her that this order existed excluded because she knows it based only on hearsay.
Okay, Mr. Crow.
You're all right. We don't object to that. If Ross is testifying, then what she heard from records, she already, I think, can explain what she's doing. She confirmed with Romo that he was there and that he wasn't supposed to be there. It explains why she did what she did, but I don't think we need to go into the fact that there was a report on July 9th that Ross took that was in Spillman that says he was trespassed, so we can have her not testify.
Okay, so we can strike that.
I think we can agree to that,
Okay,
and we'll let Miss
and then you'll advise her.
Deputy Potter know.
Okay,
And going to number 5, we don't have a PowerPoint, so we don't object to that.
okay.
And I don't object to number 6, that time for wet iron.
Okay.
And I believe the court's addressed everything that I raised in my memo.
I was gonna say, is there anything in your memo that you want to talk about? Okay.
It sounds to me like the defense is waiving a 3-5 hearing. From what Mr. Kazmarek said.
Okay,
Is that a yes?
Yes.
okay. Okay, is there anything else? Are we ready to bring the jury in?
I think we're ready, Judge.
Okay. Mr. Kazmarek, you ready?
Yes, Your Honor.
Okay.
Do you want to stay in here, or do you want to go to your,
I can stay in here, it's fine.
okay, I have to go off the record, I think, though, so we don't get
So I think what we did last time is, like, when the jurors are walking up, we go off the record because we don't want them on YouTube or video.
But when they come in, you can stay on the record, because they're not gonna be on video,
Okay. Yeah,
or should we go off the record right now?
whatever you want to do.
Do you want to stay on the record or not?
Let's stay off.
Off.
Yeah, just in case.
Okay. We'll deal with that.
Okay. And you know where to